foreclosure, the time for the statute of limitations, all of those things we just discussed, those are absolutely going to cover any real property that's out there. So that's a huge change that we weren't
residential.
Oh,
property.
yeah, exactly. The other that's 273, and it's important to note that the 273 actually came to the governor's desk after 284. There's actually a provision within 273 that changes, well, it expands some of 284. 284 was actually brought by Assemblyman Conklin, Horn, and Kirkpatrick. And the Attorney General's office, I think, was involved with this as well, as there are a lot of provisions now that are being made for the Attorney General to have the right to go after a foreclosure trustee who files fraudulent documents. So there's going to be, built into 284, what I think is going to be really beneficial to consumers is that we now have both civil and criminal penalties against foreclosure trustees who file fraudulent documents. You know, robo-signing's been all over the media.
Yeah.
Everybody's talking about the documents not being available, authenticated. I mean, you name it. There's all kinds of fraud that's being alleged, both civil and criminal. And so what our legislature has done is we now have codified that if you file a fraudulent documents with regards to a foreclosure, because we're a non-judicial foreclosure state, so everybody's on the honor system
Subject
here.
to damages.
You're subject to damages, and it's $5,000 penalty for the fraudulent document and reasonable attorney's fees, which is huge because attorney's fees have never been built in to a lot of the older existing laws within the state of Nevada. And
Is there a provision that says the greater of your damages or $5,000?
Yes.
That triples the $5,000?
Yes, we have treble on that. So
Ooh.
if you have actual damages, it's treble,
Yeah.
and your reasonable attorney's fees and costs. So now, when the robo-signers just sign off on documents without having any personal knowledge about their validity, and they record them, not only do you have a civil right of action, the AG's office can go after you.
Against the signer, against the trustee that
Yes.
employs that robo-signer?
Yes.
How about against the lender?
You know, as far as how far that liability is going to go, I think that's something that's going to come out in court. As far as how many parties are a party to it. You know, they're required to file an affidavit showing that they have the authority to act if they're an agent. So, you know, when the law was first initiated, you know, the intent of the legislation was to make it so that only a limited amount of people would be able to record a notice of default to start a foreclosure action.
Yeah.
It was expanded. You know, I think part of getting 273 to pass, which gave us a lot of other provisions that were important, they expanded the list of who now can be a foreclosure trustee. It's a little bit too legally technical to get into for purposes of today.
Yeah.
But basically, you know, there is going to be greater limitation on who can initiate a foreclosure. Their liability is going to be higher, and the demand on the lender to produce the documents to show that they're, you know, that they have proper standing for the foreclosure are going to be much greater. I don't think this is going to stop a lot of the foreclosures from happening. I think the foreclosure rate will continue just as it is. It may be a hiccup as far as documentation and administrative issues for the lenders in the very beginning, which is why they pushed the date back. It was supposed to start July 1st. 273 changed the timeline on 284 to October 1st. I think that was to
Of
give
11.
Exactly. And it was to give the lenders an additional time to work out their internal processes. And it also, one of the provisions in here is that they have to have a state business license. So all the foreclosure trustees in California, Texas, North Carolina, all these other states
Have to get
licensed in the state of Nevada. So it's not going to stop them from doing it, but it's going to make them more regulated. Certainly going to put greater provisions and restrictions on what they're doing. But the biggest thing is that when they do make mistakes and they do record documents incorrectly and they don't name the proper parties, or they've, you know, mishandled the file.
What if they don't have an original note?
Well, that's still going to be litigated here. I think, you know, the deed of trust law is that they have to show that they have standing under the deed of trust to foreclose. Whether they have the original note or not really comes up as an issue in the foreclosure mediation context and in bankruptcy court.
Yeah.
Because it is a non-judicial state. There's been a couple of different cases that have gone up on that issue, the whole show me the note.
Yeah.
And the courts here, both state and federal, have all said, show me the note doesn't apply. Our deed of trust law says...
Except for the bankruptcy court.
Right, except for the bankruptcy court. That's different, because in bankruptcy court, you're asking for a motion to lift stay, you're asking for a proof of claim, and you have to attach the proper documents to that. So it's not a foreclosure action. So
Why would the bankruptcy court be, it seems to me that the bankruptcy court is following the law, the strict language interpretation of the law and the requirements. Is it because the bankruptcy courts are more knowledgeable than these other courts, or why is the bankruptcy court here more apt to enforce the documentation and the requirements that the lenders bring the correct documentation to a foreclosure, rather than the state court and the federal courts?
I think it just comes down to you're pursuing different causes of action, and it comes down to the case law. And the case law in Nevada for foreclosure is they have to substantially comply. And what the argument has come up in the state court reference to a wrongful foreclosure is the deed of trust gives me the right to foreclose on the property. The note gives me the right to sue for the deficiency. So even if I don't have the original note, but I'm certifying a copy to you, I'm still the proper party because under the deed of trust, I have the right to foreclose on the property for non-payment.
I loaned the money.
Correct.
But
it's an issue that I think
that's kind of
needs to come up.
Greater.
Because it is. It's great because when you go into the bankruptcy world and someone comes in and they don't have an original and they don't have they don't have the proper endorsements on the note to show that note was transferred over, how can you file a proof of claim? Because think about it.
Yeah.
If you're talking about a secured debt in bankruptcy, you either take it back and file a proof of claim for the amount you didn't get, right? Or you're saying, give me a lift of stay so I can proceed with a foreclosure and do this other action outside of.
Yes.
So in a bankruptcy, when a lender comes in and they're trying to do one of those two things, their burden of proof is higher because they're trying to remove your rights under the bankruptcy code, which gives you that protection from the creditor pursuit.
Right. Okay, all right.
So I think that's the difference, at least how it's been playing out here. Now you go to states like New York, Florida, California, Ohio,
Wisconsin.
Any of these other states, whether they're judicial or non-judicial, these cases are playing out entirely differently.
What do you mean by judicial or non-judicial?
Well, in a state that has a judicial foreclosure law, like Florida, in order for a lender to foreclose on the property, they have to file a complaint in court.
Yeah.
And I actually just came back from the NCLC mortgage litigation conference. I met attorneys from all over the country that are dealing with these issues. And one of the attorneys from Florida said, it's easy for them. They have to file a complaint. And as the plaintiff, they have the burden of proof. So it's really easy to walk into court and say, show me the note. And then, of course, they can't. And so then their case gets dismissed.
They stop them.
Yeah. So
there are a lot of foreclosures or a lot of properties out there in Florida where the lender just can't foreclose. What happens?
Right. So you don't...
How does it play out?
A lot of times it turns into a loan modification. A lot of times it turns into principal reduction. A lot of times it turns into a short sale with an agreed deficiency waiver. I mean, there's a lot of different ways out because litigation is expensive for both sides.
Yeah.
And, even though the homeowners, for the most part, are in financial despair, they have a lot of consumer protection laws that make the attorneys want to take the cases because the attorney's fees are usually very high in those types of scenarios, and you get a judgment against a lender as an attorney, that's pretty easy to collect on.
So, but under the Nevada laws, as I understand it, on a deed of trust, you have the option to judicially foreclose.
Absolutely.
But lenders aren't going to do that.
No.
Because it takes longer. They are going to be forced more to task to produce the actual documentation.
Right.
And they can not have to confront or face a judge rather than doing a non-judicial foreclosure on a deed of trust. But I don't know. Who knows?
Well, and logistically, I mean, playing both sides of the fence, if I'm lender's counsel, I would much rather do a non-judicial foreclosure because the vast majority of the time you just run through the process and your foreclosure's up and you move on.
Yeah.
In a non-judicial context, people are going to get served with a complaint. They're going to go to lawyers.
Yeah.
They're going to go to lawyers and say, hey, I just got sued. What do I do? And of course, the lawyers are going to dig through it and say, oh, we have all these defenses. We're going to file an answer.
So
and so now, instead of it being an 8 to 12 month deal, we're talking up to 5 years, 5-year rule to take a case to trial here.
Yeah.
There are ways you could strategically draw it out as long as you wanted.
Maybe.
You know, I mean, so if I was lender's counsel, I'd be very hesitant and very leery. Not just because of the proof issues or the documentation issues, but just the logistics of being in a state court action and how long it takes to get through discovery and to get to trial.
Yeah.
I mean, 4 to 5 years of not receiving payment on a house. I mean, that's a huge amount of arrearages, no matter what the mortgage monthly payment is.
So we're not going to see any judicial foreclosures.
I don't think so. It's a cost benefit analysis. It's just not worth it to lenders to do it. That's the whole reason they have non-judicial in the first place, is to save money.
Seems like this new legislation is going to maybe bring things more to the forefront with consumers and borrowers who hire lawyers to go ahead and bring these things to the attention of the courts. Well, so foreclosures may end up in court anyway.
I think so. And that's one of the things I think is part of our obligation as members of the bar, is to educate people that, look, this is a huge transaction. You go back to the East Coast, you can't even close on a real estate deal without having an attorney.
Yeah.
And the fact that we've wheeled and dealed and done all these, transactions out here, and people have been taking out loans for hundreds and hundreds of thousands of dollars without any legal advice at all, is just strange to me. And now the back end of it is people are just walking away from houses or putting their head in the sand.
Yeah.
They may have viable claims against the lender if their conduct was inappropriate, if they took shortcuts. And the incentive for, I think, lawyers to take these cases is now they've built in the attorney's fees, so that the risk of the lawyer taking the case and either the client not being able to afford the litigation, or it's kind of like car accident cases. Most people that are injured in a car accident, we take those cases on contingency because they can't afford to litigate it, and the insurance companies know that. And so if attorney's fees weren't built in as provisions of a car accident case, you can go after the insurance company for bad faith or whatever your claim may be. Most lawyers wouldn't take contingency car accident cases if they didn't know they'd get attorney's fees at the end. And if you look at the history of a lot of the federal, Fair Debt Collection Act, Fair Credit Reporting Act, and some of the other federal consumer protection laws, they always have attorney's fees built in because they don't want attorneys to not take small value or no value cases.
For consumers who can't afford lawyers.
Exactly. Because let's say you do litigate one of these issues, and ultimately the only thing that happens is a lender has to go back and do the foreclosure again.
Yeah.
There's no damages. So there's not like there's a percentage compensation you can build off of that as an attorney. But if you win on the merits of your case, and even if you only get the $5,000 damages, but your attorney's fees were $100,000, you're going to get your attorney's fees. That's what the law says.
Yeah.
Which means ultimately these cases are not going to go to trial, and they're going to end in settlement.